Tell me who's on for purpose of Connie May taking roll. Who's on the WebEx?
Andrew Theisen, Jordan Mahalahan, Matt Sterling, Mike Heim, Ara Ahmed, JP, Jim Reed, Michelle Segan, Eric Smith, Samantha Potter, and that's it.
Thank you. You got that, Connie? Okay, folks, we've got a couple of, I got one bill today and one House concurrent resolution. First up, I believe we have some bill introductions today. Looking, apparently not. Well, we might have them from the audience too. Does the audience have any bill introductions? Okay, I'll save it. I think Representative Potter is not here. She came to my office yesterday. Is she on the WebEx? She is. Representative Potter, are you on the WebEx?
Yes, I am. I raised my hand on here. Sorry, Chairman. That's
all right. Do you have bill introductions?
Yes, I have a bill introduction. The RS is 8. It would require Kansas employers to verify employment eligibility of employees and would remove the ability for Kansas employers to claim those who are ineligible to work in the United States on their Kansas taxes.
Okay. Could you repeat the RS number, please?
1158.
Thank you. Without objection, it's accepted. Do you have other bill introductions?
Not at this time. Thank you, Chairman.
Thank you. No further bill introductions, and bill introductions will be closed. Committee, if I could have you open your files or your computers to House Bill 2224, expanding the definition of infectious diseases in certain statutes related to crimes with bodily fluids may have been transmitted from one person to another. I have 3 proponents listed. First up, oh yeah, the reviser. Give me an overview. Thank you.
Absolutely. Thank you, Mr. Chairman. And good morning, committee. House Bill 2224 would amend KSA 65-6001 and 6009 concerning arrested and convicted persons and infectious diseases. Under current law, when an individual appears before a magistrate, if it appears from the nature of the charge that body fluids may have been transmitted between persons, the victim of the crime or the county or district attorney may request that the court order infectious disease tests of the alleged offender. If any counseling or testing is provided to that individual, the court is required to order the adjudicated person to pay restitution to the Department of Health and Environment for the costs. The results of any tests are disclosed to law enforcement officer making the arrest, the person arrested, and the victim. Lastly, under current law, infectious disease for these provisions is defined as AIDS and hepatitis B. So that brings us to House Bill 2224. The bill would expand the definition of infectious disease to mean any diseases that were designated by the Secretary of KDH&E through rules and regulations as infectious or contagious. Additionally, the bill would expand who would have to pay those restitution costs for testing to include persons that were arrested and tested because it appeared they may have transmitted fluids to other persons. And I'd be happy to try to answer questions the committee may have.
Thank you. Questions for the reviser? Representative Hauser.
Thank you, Mr. Chair. Matt, would COVID-19 be a disease that would fall underneath this?
So anything designated by the Secretary of KDH&E through rules and regs as infectious or contagious would be included under this. So any current or future disease that the Secretary designates as contagious or infectious this would apply to.
Thank you. Thank you, Mr. Chair.
Thank you. Representative Heiberger.
I think I may just have found it, but do you have a KAR number for the list of infectious diseases?
I can look that up quickly and get it to you. I don't have it off my top of my head.
Okay, thank you.
Thank you. Representative Clayton.
Thank you. And Matt, my question is, how exactly is bodily fluid transmission defined? I mean, obviously for some disease spread, it's a little bit easier. So for instance, if someone were to spit on someone or to cough in someone's face, would that fall under that definition? It's not totally clear to me.
So there is not a definition in the statute for that transmission of bodily fluids. The provision in 65-6009 pertaining to this simply states that if someone's charged with a crime in which it appears from the nature of the charge that the transmission of bodily fluids from one person to another may have been involved, then those tests are ordered.
Thank you. Thank you, Mr. Chair.
Thank you. Further questions for the reviser? Yes, go ahead, Trevor Jacobs.
Thank you, Mr. Chair. Matt, if I may, on line 22, the first page, and line 23, why is this language necessary in this bill? On the first page, that definition of racial ethnic group, that's current law. I'd have to go back and look at other provisions of the Act to see where that definition is used, but the bill would not change or add that definition. That's what's currently in law. Thank you, Mr. Chair.
Thank you. Further questions of the reviser? Seeing none, we will go to the proponents. Ed Klump, Kansas Association of Chief of Police, Kansas Sheriff's Association, Kansas Police Officers Association. Good morning, Ed, and welcome to Federal and State Affairs.
Members, turn the mic on here. Thank you, Mr. Chairman, committee members, for allowing us to come and testify on this bill today. This is a very, very important bill for us in today's world. We actually initiated work on this bill last year before COVID struck, and the bill was introduced before COVID was here. But after COVID, it became even more important to us. And I'll explain what is going on with this bill and why we need it. This particular article of Chapter 65 has to do with these infectious diseases, and in it is two statutes that pertain to emergency service providers. 65-6009 pertains directly to persons arrested, so it affects directly law enforcement. And you see that statute in the bill. The other statute is 65-6008, which you do not see in the bill because there's no amendment to it. And that statute provides this testing mechanism for corrections officers, firefighters, EMS, and medical staff when they are exposed to the body fluids. So to fix that, we started working with KDHE in how we could fix this. And the legislature several years ago, I forget exactly what year it was now, directed KDHE to establish by regulation the infectious diseases that were commonly encountered by medical workers and first responders. And so it seemed to only make sense, since they've been directed to identify those infectious diseases, to use that list in these statutes. And if you look at the bill on page 2, line 8 through 10, and then on page 3, lines 19 and 20, that is the meat of the bill. And what this does, you'll see on page 3, lines 19, 20, it was restricted only to HIV and hepatitis B in current language. In the definitions in 65-6001, which is section 1 of the bill, there on page 2, lines 8 through 10, you see that the previous or the current definition only includes AIDS and nothing else. Doesn't even include hepatitis. And so what the KDHE proposed to solve this is to change that definition in 65-6001, which you see there on page 2, so that it references that regulation that they developed. And then to fix 6009, we simply struck what's on line 19 and 20, which was a definition of infectious disease just for that statute. So by striking that, it now references the definition you see on page 2. And by changing the definition on page 2, then we fix what was wrong with 6008 without actually having to amend that statute. So that's how we get to the bill. Mr. Chairman, I know there's going to be some testimony later on concerning some language in the bill on page 2, lines 28, I think it is, and page 3, lines 24. That was not a language change we proposed. I think that probably was something that happened in the revisor's office to just correct some language. So I don't think we have a particular care about what that language says. We haven't had any problems with the current language that I know of, but there may be a legal technical reason that change was made, but it was not something that we requested. So I just want to clarify that. You'll also see some other technical amendments that were made in the bill in various parts. So this is very important to us because to answer the question, Representative Clayton, about the exchange of body fluids, these are the typical scenarios where this particular statute play out. I cannot tell you in my 35 years of law enforcement how many times I had to go in mid-shift and shower because I was covered in other people's blood, or they had spit on me, or they had vomited on me. And so those are the common exchanges of body fluids that we see. And believe it or not, many times when we're arresting a person, whether that exchange of body fluids is intentional, such as spitting on us, or if it's unintentional, they really love to just throw out there, and I've got hepatitis, or I've got HIV, or I've got COVID, which is what we're hearing today. And so when they say that, you don't know whether it's true or not. And so the mechanism of these statutes allows us to get this testing done. And it's more expedient for us in law enforcement when they're arrested because it allows the judge at the time of first arraignment to order that testing if we present them with the evidence of that exchange of body fluid. So that's how this is typically played out. Mr. Chairman, I think that covers the important points I've expressed in my written testimony, why this is so important to us. I think I've explained that here. We appreciate the committee's time on this bill, very important bill, and be glad to answer questions when the time's appropriate.
I've got one now.
Okay.
I'm going to direct you to page 3, line 24.
Right.
The original language was the court shall order the adjudicated, and then you have arrest or convicted. Are you agreeable that the court only has jurisdiction upon a conviction, so not an arrest? Someone may be arrested and the prosecutor, for whatever reason, doesn't say they can't, the police officer or the fire department individual or EMT can't get tested, but the court normally doesn't impose any restitution until a conviction. So,
yes, Mr. Chairman, the way I read, and again, this was not our proposed change, but the way I read that is line 24 there is unique to subsection C, or E, I guess it is, and it becomes D in this change, but whatever that subsection is, it pertains to that process, which is the restoration of the cost of that. So I agree with you that if a person is not convicted, typically there is no methodology for a court to order any kind of a payment from that person for anything that's been ordered. So I would agree with your assessment of that section. I did find it odd that it was the word adjudicated, because that is typically what is applied to a juvenile. And so that really didn't make a lot of sense. But so perhaps if it said adjudicated or convicted in that person, not the arrest part.
And I would propose, if we work the bill, it would read, the court shall order the person upon conviction to pay restitution to provide it under the sections above and type thing. But
You might want to leave adjudicated in there in case it's a juvenile case.
you know, that's a good point.
Yeah.
Because we don't convict juveniles, we adjudicate.
Right. Yeah.
And I could see that. All right. Well, if and when we work this bill, I will maybe ask the reviser to update that.
Be glad to work with anybody on that.
Okay. Good enough. Further questions of the conferee? Thank you.
Thank you.
Next up, I have Farah Ahmad, State Epidemiology, Department of Health and Environment, by WebEx. Are you there? He is there? I see Matt. Are you there, sir? Mr. Ahmad?
This is Dr. Ahmed. Can you hear me?
Yes, we can. Could you turn your volume up a little bit? Could you?
I'm on max, but I'll get closer to the phone. Am I okay now?
Okay, you're good now. You're good.
Okay.
Thank you so much for appearing.
Thank you. Thank you. To Chairman Barker and members of the committee, thank you for the opportunity to provide written testimony in support of House Bill 2224 related to potential exposure to infectious diseases during the act of committing a crime and while performing law enforcement activities. The KDHE Secretary under KSA 65-101 has the authority to adopt rules and regulations necessary to investigate the causes and prevent the spread of diseases. KDHE updates the list of infectious and contagious diseases and other health conditions in KAR 28-1-2. We did update this list in May of 2018. The House Bill 2224 updates the definition of infectious disease in KSA 65-6001 to include those diseases designated by the Secretary of KDHE as infectious or contagious in nature, and replaces that narrower definition of infectious diseases as just AIDS. So Senate Bill 320 also strikes from KSA 60-6009 the definition of infectious diseases as only HIV or hepatitis B. So there's no intent there's no change in the intent to KSA 65-6009, where the alleged victim and law enforcement are to be notified that infectious disease tests are available where there appears to have been a transmission of body fluids from one person to another by any person arrested and charged with a crime. Also, if the person arrested and charged with a crime states to the law enforcement officer making the arrest that he or she has an infectious disease, the court can order the arrested person to submit to an infectious disease test. Similarly, upon conviction of the person for the crime, where the facts of the case involve the likely transmission of body fluids, the court may order the convicted person to submit to infectious disease testing. So this bill really just broadens the list of diseases considered infectious and contagious for these purposes. So thank you for the opportunity to share our support for the bill, and I'll take any questions.
Thank you. Questions from the committee? Representative Hoyt.
Thank you, Mr. Chair. I just have a point of clarification here, because my understanding is it's not the court can order the arrested person to submit infectious disease tests, that it shall order. So if this person is arrested and stated that they have an infectious disease, such as we heard, oh, I have COVID, then the court is required to have them submit for a test. I just want clarification on that, please.
That is a good question. That was not a KDHE recommended wording. Really, our concern was just in the updating of that very narrow definition of infectious and contagious disease. So I don't know if Ed has a say on that.
That would probably be a better question for the reviser. Okay. Further questions of conferee? Seeing none, thank you for appearing today by WebEx.
Thank you.
And I'm going to go to the next, John Goodyear, League of Kansas Municipalities, and then we'll come back, Representative Hoyt, to your question. Good morning, sir, and welcome to Fed and State.
Thank you, Mr. Chairman, members of the committee. Thank you for the opportunity to come before you today and give testimony in support of House Bill 2224. And what this bill does, and you heard from the reviser, you heard from the prior conferees, what it does is expand that definition of infectious disease, and the importance of that is for what kind of tests can be ordered. The League supports expanding this definition as a measure to help protect the victims of crime, to help protect our first responders, protect law enforcement officers that are serving our communities. Officers are at times, just as a nature of their position, subjected to an increased risk of exposure to these infectious diseases, and by broadening the scope of the tests that can be ordered, officials are going to be better informed of the occupational risk. They're going to be it's going to be allowed for more rapid testing and more rapid treatment of officers and victims of crimes if they are exposed to these infectious diseases. We welcome this update as a definition to allow for greater protection of Kansans all across the state, and ask that this committee would recommend the bill favorably for passage.
Thank you.
Thank you, Mr. Chairman.
Questions? Seeing no questions. Oops. I'm sorry, who? Oh, Representative Wagner, yes.
Thank you, Mr. Chairman. Just a basic question. Do you have cases where law enforcement or other people have actually come down with infectious diseases by exposure to a criminal person, or is this more just the desire to be tested just to make sure you don't have it, or do you actually have situations where they have gotten illnesses?
I'm not sure that I have anything more to offer you, Representative, than anecdotal evidence. Ed might be able to contribute more to that, Mr. Klump, rather.
Ed, I think you're probably more qualified to answer.
Yeah, thank you, Mr. Chairman.
All right, thank you. Further questions of this conferee first? Seeing none, then I'll ask Ed to come back up. And you could also address Representative Hoyt's question, I think. And I'll have her repeat.
Yes, sir, I will. Ed Klump with the Kansas Sheriff's Association, Kansas Association of Chiefs of Police, Kansas Peace Officers. In answer to your question, yes, there has been cases. The most frequent that we run into prior to COVID was hepatitis. And under the current statute language in 65/2009, we could only test for one type of hepatitis, and the most common had changed to a different type. And that's what drove us to look at this and get this bill initiated in the first place, because courts were declining to give us the testing order for the hepatitis C, I think it was, because the language of the bill did not include that. There's no question that there's probably been some transmittal of COVID during this, although, as you know, it's difficult to say exactly where you pick up infectious diseases. But we certainly know that we've had officers who did test positive who had been in these situations with the person who also tested positive. So there's a pretty strong likelihood that has occurred on occasion. In response to the other question, that is existing language. It's been in the law since the law was created. You know, it's, I think if I read the language correctly, and I'm not an attorney, but it seems to me that you present the evidence that these things occur, and then the judge is required to issue the order. It's not like he's required to issue the order without evidence. That you still have to present the facts to get that accomplished. And that's true whether it's 65-6008 for the other first responders or 65-6009 for law enforcement.
Does that help, Representative Hoyt?
Yes, thank you. That's an important clarification.
Okay, thank you.
Good. Further questions? Seeing none, thank you again.
Thank you, Mr. Chair.
I would direct the committee to two written proponents, Mike Shank with the Kansas State Lodge Fraternal Order of Police, and Bob Wing, well, it's Robert Wing, Kansas State Council of Firefighters. Both of them, these individuals have appeared in the past in front of Fed and State. I have no other proponents. Anyone else in the audience that would like to be a proponent? Seeing none. That part of the bill is closed. I will go to the opponents. I have one, Tom Witt. Mr. Witt is here today. Good morning, sir, and welcome to Federal and State Affairs.
Good morning, Mr. Chairman. Good morning, committee. I think my objection to this bill was addressed by a previous conferee, Mr. Klump, but what caught our attention on this, I'm with Equality Kansas, which advocates for non-discrimination based on sexual orientation and gender identity. And what caught our attention on this was striking AIDS, HIV from current statute and replacing it with the entirety of the infectious disease list that KDHE maintains. In the 80s and 90s, there was a pretty big wave of anti-gay legislation across the country that targeted people with HIV, and we like to see this stuff removed from statute. So we really liked that part of the bill, but then we got to the very end, which was previously discussed, where the standard for compelling a test and ordering assessment of fees and counseling costs against somebody who is merely arrested, not even charged, just arrested. We see that as opening the door to some potential injustice and possible abuse. And there's also, if you look at page 2, line 28, similar statement that such arrested person rather than arrested and charged. Again, arresting somebody is pretty easy. Bringing charges is another step. And we would prefer to see the statute remain as it is, where somebody has to be charged before they're forced to undergo medical testing. And one of the problems with the medical testing, if you look at page 3 at line 7, section C, that subsection C, that's the list of everybody that gets your medical history disclosure. And a lot of the people on that list have no duty to keep that information private. Okay? So somebody could be arrested, never charged, never convicted under this proposed bill, and they could have their medical condition or medical history made public against their will, even if the case against them never proceeds past the arrest stage. So it's on that basis that we would oppose the bill. It sounds like it's going to get fixed, and I thank the committee. And I'm happy to stand for questions at the appropriate time.
Thank you. Questions for the conferee? Representative Woodard.
Thank you, Mr. Chair, and thank you, Mr. Witt, for your testimony. My question just has to do, which I think you have addressed, if the amendment that was, if we were to work this bill, if that amendment were to be made, would that remove your opposition from the bill?
Absolutely. We would actually support the bill at that point because it does strike HIV/AIDS from statute and goes to this rather lengthy list that's attached to my testimony where all the infectious diseases are cataloged by KDHE.
Thank you. Thank you, Mr. Chair.
Thank you. Representative Penn.
Chairman. Thank you, Mr. Chairman. Thank you, Mr. Witt, for appearing today. Going back to your discussion on page 2, line 28, talking about the arrested and charged piece, is it your position that even after what we saw over the summer, when a person comes into the custody of the police, when they're arrested, they are now controlled by the police, and to be charged might take a number of different steps, may not matriculate into a charging.
Right.
However, the first responders have already been exposed to transmission of the list that you say that you have on your written testimony. So if they're in the custody of the state at the arrest phase, and they indicate that they have transmitted said fluids or infectious diseases, would you hold that it's okay or advisable for them to actually undergo said testing while in the custody of the state, because the charging phase may never occur and the first responder is still exposed without a determination?
Okay, so my understanding of the current statute is that where the requirement for the test kicks in isn't just because the suspected offender has made a statement against their own interest saying, I have COVID, or I have hepatitis, or I have AIDS, but the authorities that have taken custody of this person can suspect that that individual is infected and could impose a test. So again, just the mere fact of an arrest, I don't think is a high enough standard for compelling somebody to take a test and then making those results public. I think, and this is hot take on your question, so bear with me, but you know, I think if somebody was compelled to take a test under that standard of having been arrested, I think if there was an exception in that sub C, where it wouldn't be disclosed if the person is never charged. I don't know how you make that work, but again, we're talking about the privacy of Kansas citizens who have not been charged with or convicted of a crime.
Thank you for that, sir. I look forward to working with the members to find that balance between protecting our first responders and protecting privacy. Thank you.
And I'll add, you know, it's kind of tough to come up here and oppose a bill backed by law enforcement. Not my favorite position to take.
Thank you, Representative Lowe. Hal, I'm sorry.
Thank you, Mr. Witt, for your testimony. I appreciate you bringing up some very valid concerns. My question is either for you or the reviser. Should line 11, 12, 13, and 21 on page 1, it's the definitions of what AIDS and HIV is. Should that also be struck from the legislation?
Okay, I can actually answer that. No, because they're in between 6001 and 6010. There are 8 other sections to the Act that those definitions refer to. So they need to stay. When I first looked at this, I had the exact same thought you did. But then actually opening the statute book, it was like, oh yeah, we need that stuff.
Thank you.
Questions of the conferee? Seeing none, thank you.
Thank you, Mr. Chairman. Thank you, committee.
We have one written opponent, Max Iverson, Kansas Association of Criminal Defense Lawyers. You may, at your leisure, read his testimony. Anyone else appearing as an opponent? Seeing none. Anyone appearing as a neutral? Again, seeing none. I will now close the hearings on House Bill 2224. There will be some amendments when we work this bill. I think the chair has a couple. But anyways, I expect to see this bill, or you should see this bill maybe tomorrow. That will give you an opportunity to visit with the reviser if you should want to bring an amendment. I'm now opening the hearing on HCR 5008, urging the U.S. Congress to extend daylight savings time throughout the year for the whole nation. With that, Matt, if you'd give us an overview.
Sure. Thank you, Mr. Chairman. And before I jump into that, if I can just quickly jump back to add some additional information on the question that Representative Hoy asked. So the court, it is the court shall order a test, and there's actually 3 circumstances under which the court orders the test. And that is if the victim of the crime requests it, the county or district attorney requests it, or the person arrested and charged with a crime states to law enforcement officer making the arrest that they are infected with an infectious disease. So there's those 3 circumstances under which the court is required to order the testing.
Thank you.
Yeah. So House Concurrent Resolution 5008, as was stated, it's if adopted by the House and the Senate, would urge the United States Congress to extend daylight saving time throughout the year for the whole nation. A point to know about this is not something that the state of Kansas can just change for themselves. It's preempted under federal law, so that's why you have a resolution urging Congress to take action, because it's not something that the state of Kansas can alter. That's basically all I'd have for it. Is you can see, there's the whereas clauses for why the change should be made, and the resolution would just be urging Congress to change it. I'd be happy to try to answer questions as well.
Thank you. Questions for the reviser? Yes, Representative Arnberger.
Thank you, Mr. Chair. My question may be for research. What other states have already done a resolution like this?
Jordan, are you on?
Sure, thank you. I don't have that information handy. Perhaps maybe some of the conferees would have that information. It looks like we're getting some nods, but if not, I can always send a follow-up email afterward.
Thank you. Further questions for the reviser or research? Yes, Representative.
Thank you, Mr. Chairman. My question has to do with Arizona. Are they currently standard, or which time are they in? Because I know they've had one for the last 40 years.
And that's directed to?
The reviser.
Reviser. Matt?
You're gonna trip me up in terms of, I know that there's a federal exemption for Arizona, so that's part of why they're able to be different. I think one of the conferees could probably explain better whether that's the standard or what that is. I don't know the distinction. Just only that they are only an hour different. So I'll let the conferees answer that better than I can.
Thank you, Mr. Chairman.
Thank you. Further questions of the advisor? Research. We have listed two proponents appearing today, Representative Shannon Francis. Representative Francis, welcome to Federal and State Affairs.
Thank you, Mr. Chairman and members of the committee. I am glad to be in Fed and State Affairs. You guys handle a lot of weighty members. Sometimes when I'm questioned about some of the bills that you have to deal with daily, I often kind of joke that I'm on appropriations and transportation because I want to be. So I value your service. I know it's a difficult job. Hopefully this is one of those items that might be a little bit easier than some. I believe we maybe have 3 or 4 conferees, but just to answer one of the earlier questions, this debate on changing the clock annually has taken place in 40 state legislatures last year, and this year, the date of this article, excuse me, is 12/8 of 20, will come under consideration in 32 states this year. There are 77 bills and resolutions under review. 2/3 of the pending bills advocate for year-round daylight savings time, with the remainder favoring staying in standard time. You know, how I got here is Representative Williams had a Facebook post. We all know how scientific Facebook posts are. But a couple of years she had one of those, and I kind of wanted to be the devil's advocate, so I shared it on my Facebook page. My community is 2 miles from the Oklahoma border, and I thought it was going to get roundly dissed on Facebook. Surprisingly enough, the overwhelming majority of my constituents said, we're sick of changing the clock. Every clock change when I go to church, a friend of mine, it's a lady that's a little bit older than me, I shouldn't have probably said that, but Jean Ratzlaff, she goes, when are you going to do something about the time change? So this is my attempt after doing some different things to to do something about the time change. As part of my testimony, you'll see a recent survey that I did on Facebook again. I had 108 responses. 60% of those wanted daylight savings time year-round. 14% of them wanted standard savings time year-round. And if most of you know me very well, I'm a standard savings time kind of guy. You know, I generally wake up about 5 in the morning. I go do my run or something like that. I'm always upset because it's too dark, you know, especially this time of the year. So just when you're arguing why should it be daylight savings time instead of standard savings time, I get it, you know. But the overwhelming majority of my constituents, again, 60%, like daylight savings time year-round rather than a standard savings time. 20% of my constituents said they don't care, they just want to quit changing the clock. And I understand that also. 4% said we don't want any change. As I did some research, I saw that a lot of the concerns about we can enact standard savings time as a state, exempt ourselves out of daylight savings time if we so choose. But it creates a lot of problems if you're on a border community, if you're 2 miles from Oklahoma, if you live right across the Missouri line. If the other states don't change, it creates a problem. But because of the federal statutes, we can't go to daylight savings time only. So I thought this was a good way to approach it. If the nation as a whole would standardize on one time, it'll make a lot of our constituents feel a little bit better about it. I would also like to respond to, there's a whole bunch of studies out there on why to standardize the clocks. I listed a whole bunch of these at the end of my testimony. I really do think that most of these, the reason to quit changing the time is it messes with our circadian clocks. We're going to adjust to whenever the sun actually comes up, to whenever it sets by the activities we want to participate in. But I do think that there are real problems that it causes for the safety and the mental health of individuals throughout the state, whether they be children or seniors, just adjusting to that minor clock change each year. So I know we've got some other experts that probably can give you more in-depth explanations of some of these. Oh, another reason that it's good for us to pass this, there is movement happening on the federal level. In 2019, Senator Marco Rubio introduced the Kansas the Sunset Protection Act, and that was a bill to permit states to observe permanent daylight savings time. So this is the one thing we can do to show our federal delegation that we support locking the clock. We have all of these cute little things, by the way. If you want to do some more research, you can Google pound lock the clock or pound ditch the switch. There's just a lot of resources out there in favor of that. So again, I hope you'll support this information. I think it's something our constituents want, and it's a way to move the ball forward. So I would be happy to stand for any questions.
Thank you, Representative. Arnberger first.
Thank you, Mr. Chair. Just a clarification. When you say pound, is that a hashtag?
Yes, okay. Mr. Chairman, for people of our age, wasn't the pound sign now isn't a hashtag? Aren't they the same thing, I think?
In my opinion, they are. But
generational issues that we have. I'm sorry, Representative.
Representative Epley.
Thank you, Mr. Chairman, and thank you, Representative from Liberal, for bringing all this information to us. It's a lot here, these studies, and I want to kind of drill down on one aspect of this that I think might be overlooked, and I want to ask your opinion. In your research that you've done on this and through your testimony, is there much of a economic churn with going to permanent daylight savings times that you're aware of? I've had constituents reach out to me on this, and they feel like it would be very positive for their businesses.
I know that there are businesses that feel that way. The businesses that you and I discussed, golf courses, they feel like it's very helpful for their businesses when this happens.
Thank you. Any information about convenience stores or other?
They've been mentioned in some of the research. I haven't delved into that specifically, but yes, they are mentioned as the business groups that will support this.
Okay. Thank you very much.
Thank you. Representative Miller.
Thank you, Mr. Chairman. And that was really a mean thing that Representative Arnberger did, almost as mean as him bringing up that lady's age and then naming her.
I think I was discreet about that. I said
no, I don't think
older
you were.
than me.
No, yeah, that's not very discreet. Looking at you, you have an impressive list of short quotes here from various sources. Is there any way we can get the actual source? There's a couple of them in particular I'm interested in, such as the one here from the Department of Energy, or if research could help us on that, Mr. Chairman. But the specific question I have as it relates to that list, have you read these? Is there any way you can explain how staying in daylight savings time can save wildlife? I don't relate to that one. How would that work?
You know, honestly, I looked at the research and I copied the title of the article, and then the source is the one underneath it, so that anybody could Google them if they wanted to go into it more, but I didn't specifically go into the wildlife one.
But if I may, Mr. Chairman, it is a rather impressive list of facts, if you will, and it would be good to have the actual references to follow up. If these things are all true, it makes a very compelling case. Thank you, Mr. Chairman.
And Representative, I would just say that as you delve into these more, a lot of them deal, I don't know about that one specifically, but as you dig into this, it seems like it's the changing twice a year that results in these improvements in some areas. It's really not whether you go to daylight savings time or standard. I just wanted to be clear about that.
Thank you. Last question, Representative Hoyt.
Thank you, Mr. Chair. I had a couple of questions regarding the school children and then the traffic safety. As somebody who is recently hitting the road early in the mornings in winter months and driving an hour to work, I kind of placed my head of what we would be like, and we'd be dropping off our son at school in pitch darkness, and by the time I get here to the Capitol, 8 o'clock, it would still be pitch dark. And so I'm just wondering how that, you know, saves traffic safety, and also is it more difficult for children to arrive at school and wake up and get up and at them if it's still dark outside?
So again, I would say two things. One, and it may not be as pertinent to parts of Kansas as it is other parts of the nation, but in many parts of the nation, while it's just as dark in the morning. I mean, I think we all just went through the winter equinox and we saw how dark it actually was. So we also have that problem in the evening also. You know, there's a lot of people picking their kids up from after school activities in many parts of the nation where it's dark at night. This would alleviate that. Doesn't do a thing for the problem we have in the mornings. And again, what most of the articles talk about is the consistency of the time change, where we're not trying to adjust our sleep habits based upon what an arbitrary thing like the clock actually says, I think is the major determinant as far as the safety. And just a side comment real quick is, we think sometimes that we've always done this. This changing the clock twice a year is really relatively new. It happened during World War I. For a while, it happened during World War II. And I think if you look at the whereas, it started again during the oil crisis in the 70s. So, you know, this isn't a centuries-old custom that we've had throughout the world. You know, I mean, the United States actually, I don't remember which year it was, but instituted the time zones. At one time, it was all railroad time, and time changed as you went west. So I do know about the concerns that you have. I would also say that I think it's more harmful for the kids doing that time change every year where you've got to get them up and you've got to get them to school during that one time change than some of the concerns about bus safety and those things. Not trying to minimize them, though.
Thank you. Thank you, Representative. I'm going to move to the next conferee. Scott Yates with Lock the Clock on WebEx. Scott, are you on WebEx?
I am. Excuse me, I am. Can you hear me okay?
We can. Thank you, sir.
Thank you very much. It's an honor to be here. Chairman Barker, Vice Chair Arnberger, Ranking Member Ruiz, and Representative Francis, and members of the Federal State Affairs Committee. Thank you very much. My name is Scott Yates from the neighboring state of Colorado. I'm the leader of the international movement known as Lock the Clock, otherwise known as a guy who just blogs about daylight saving time as a hobby. Before I get into my prepared testimony, and I can cut it brief if there are other questions, I wanted to just address a couple of the points that came up just a second ago. Representative Miller, the sources are all available on the website, which is just my website, and Representative Francis can provide that. It's sco.tt/time, and click the research tab. I can tell you the research about the wildlife is that if people get out of work earlier and not during the dark, most of the wildlife accidents with traffic happen right during the transition between day and night. And so if you have more traffic earlier in the day, you have fewer vehicle versus wildlife collisions. And then on the question about schools, kids going to school in the dark, that's always a concern. And, you know, if we've learned anything in this last year, it's that schools actually can be pretty flexible about their start times. And I think this is a great opportunity for schools to really figure out what's the best time for learning for the schools to start. I will tell you the Department of Transportation researched it, and the bottom line was that for every accident involving school kids that happens in the morning, there are 6 accidents that happen in the afternoon. 6 accidents in the morning compared to 1 in the afternoon. That is, it's 6 times more safe for kids to be coming home in the daylight versus coming home in the nighttime. So anything that we can do to have kids be able to exercise for one thing, but then also to be coming home, it's much more dangerous for kids to be coming home after dark than it is for them to be going to school in the dark. And then I can run through my prepared testimony kind of quickly unless you just want to ask questions. The bottom line is, and I think this testimony was submitted to you, but the bottom line is that HCR 5008 that Representative Francis bill is actually the perfect combination of the right approach to take from a state legislature. There are 15 states that have already passed something. I can tell you that the energy and the enthusiasm from states around the country is higher this year than I've ever seen it. It used to be kind of a question of, you know, do we really want to be the first state to do this? Last year and the year before, the question was, you know, well, it seems like maybe this is the right time. And now we have a question of, you know, well, we don't want to be the last state to pass something. But I will tell you, most of the things that get passed aren't actually that useful as legislation because of the federal controlling legislation. And so a concurrent resolution, all of the laws that are getting passed in all these other states essentially have the effect of being a concurrent resolution. They have the effect of saying, this is a thing that we as the state want. And I can tell you that what's gone on with the federal bills is that, like with Rubio and then also with 2 different bills that are going through the House, is that their number one way of finding co-sponsors for their bills at the federal level is to ask the representatives and the senators from the states that have passed something if they would be co-sponsors, based on the fact that their state has already expressed a desire to have to stop the changing of the clock twice a year. And that's a technique that always works. So this kind of concurrent resolution is the perfect vehicle because it avoids all of the confusion and all of the agita that goes along with trying to pass a law, and just does the heart of what's needed, which is to send a message that we need a fix at the federal level. So anyway, happy to answer any other questions. One other thing that's come up that, you know, I know that there's opinions out there that it would be better to be in permanent standard time. I will say that there is some science that says that from sleep researchers who say that would be better for the state to switch into permanent standard time. There are some other sleep researchers who dispute that, who say that it's negligible. But I will say the science overall is that two things. One is the most important thing is to get rid of the switching, that's the thing that's most dangerous right off the bat. And then the other thing is that if you survey sleep scientists, but then also survey people in the fields of, for instance, adolescence and exercise, mental health, traffic safety, crime, workplace productivity, all of those experts would say that permanent DST would be better. I do think that because Kansas is on the far western edge of the central time zone, the part of Kansas that is in the central time zone, it might make sense at some point for you to examine being in standard time. That's a question that I think is certainly up to the people of Kansas and to the Kansas legislature. And one of the things that I'm working with in my inbox is packed every week with emails from staffers of representatives and senators in DC. And one of the things that I'm working with them on is to make sure that if, for instance, Senator Rubio's bill would put the whole country onto daylight saving time right away, one of the things I'm working with his office is to make sure that if a state wants to switch to standard time at some point, that there's a relatively easy mechanism to do that. But bottom line is Representative Francis has a brilliant resolution. I would urge its passage, and I think it's the right message for the people of Kansas to send to DC to try to finally end this anachronism of changing the clock twice a year. I'm honored to be here and happy to answer any questions that you might have.
Thank you. Questions for the conferee? Representative Miller.
I wondered if it would be a good time to try to talk about killing two birds with one stone. I'm bothered that such a tiny section of Kansas is in a different time zone. Who sets time zones, if this conferee knows?
Thank you very much for the question. Ultimately, it's the state legislature. It has to do it in conjunction with the Department of Transportation, and you would have to make an appeal to the Department of Transportation to be able to unify the state. If you were to do that, it would almost certainly be approved, because one of the considerations that goes into the Uniform Time Act of 1966 is unifying state borders. They like to have a state be entirely in one time zone. So if you wanted to approach that now, I'm sure the Department of Transportation would be open to that.
Thank you,
Thank you for the question.
Thank you. Further questions for the conferee? Representative Howe.
Thank you, Mr. Yates, for your testimony. My question is in regards to people that advocate one way or another regarding energy issues. I know the United States Congress back in the Energy Policy Act of 2005 enacted and extended daylight savings times by 4 weeks because they believed it would reduce energy consumption. Can you speak a little bit about any headwinds you're seeing about energy issues affecting this policy?
Thank you very much for the question. I would say, I've looked at a lot of research in a lot of great detail, and I would say that the energy is one where there is very little evidence that's overwhelming in one direction or another. The roots of this go back to World War I, as we know, and it was supposedly an effort to save fuel oil, and so that the legacy of that sort of continues on with the anachronism that is the daylight saving time change. But the lifestyle that we live these days is so different that actual energy usage, the results are decidedly mixed. There is, for metro areas, a lot of good research that it will actually help reduce pollution, because you have the afternoon rush hour. If you go to permanent daylight time, you have the afternoon pollution while there's still sun, so it burns off a lot of the dangerous ozone. So from a pollution standpoint, it's much better to be in your own daylight saving time. But on actual energy usage, it's basically a wash.
Thank you. Thank you, Mr. Chair.
Thank you. No other questions? Thank you for appearing here today by WebEx, sir.
Thank you very much. It's been an honor.
I have no other proponents appearing. I would direct you to the written proponents. Representative Christy Williams. The testimony should be attached. I have one opponent, JP Save Standard Time by WebEx. Are you on, Mr. P?
Yes, sir.
All right, you may proceed.
Hello. Thank you for having me. It's an honor to appear before you. My name is JP. I'm the founder of Save Standard Time, a nonprofit public benefit campaign working throughout North America. I'm asking that you oppose HCR 5008. It should be referred to the Health and Safety and Education Committees. It should be amended to permanent standard time. This bill seeks to end clock change, which is a good idea, but it goes about it the wrong way by seeking permanent DST. Permanent DST is an extension of daylight saving time into the winter, and there is an immensely important reason that we don't observe DST in the winter, because it would delay the winter sunrise to 9 a.m. Now, most school and work begins around 8 a.m. So for 4.5 months, October to March, more than a third of the year, you would be forcing most people to start school or work in the dark. They wouldn't see sunlight until lunch break or even until the end of the day. And that's depressing and it's dangerous. Permanent DST reduces sleep, it reduces immunity, it increases illness, it increases accidents. It's not just the clock change that harms. Clocks are not arbitrary. When we do things matters. If you were to ask most people, would they willingly set their alarm clock an hour early every day? Would they wake themselves hours before sunrise in the cold, dark winter? They would say no. But that's what permanent DST means. Permanent DST was hugely unpopular in World War II. It was hugely unpopular and even illegal when it was tried again in the 1974 oil crisis. Countries that try permanent DST do not adjust to it. They sleep less, their health suffers, and they eventually seek to revert it. Permanent DST is opposed by the National PTA, the National Safety Council, the American Academy of Sleep Medicine, and many more organizations. Every advocacy group for health, safety, and children's well-being that has spoken on this issue urges against permanent DST and for permanent standard time. Permanent standard time keeps the sunrise before 8 o'clock in the morning. It saves the morning sunlight, which doctors tell us is most necessary for our mood, health, safety, learning, and productivity. Morning sunlight helps you wake naturally. It helps you feel good and active. It keeps you on time. It keeps you healthy and alert. Permanent standard time is also pre-approved by federal law, which would make it the quickest way to end these unpopular clock changes. So in summary, please, I ask you to listen to this scientific consensus. Do not repeat the bad history. Stop this bill and see that it is amended to permanent standard time. And I thank you for your time and service.
Thank you. Questions of the conferee? Seeing none. Oh, Representative Miller.
Mr. P.
Yes, sir.
What would keep schools from changing the time of starting school to adjust?
Well, inertia is a big one. Disruption of parents' work schedules. Right now, we're already seeing biologists say that we need to start school an hour later. But if you were to move to permanent DST, then they would need to start 2 hours later. You'd be undoing the positive benefits of starting school later with permanent DST.
But actually, neither daylight savings time nor standard time dictates when people might be required to go to work or when schools might decide to open. That's their choice regardless of what time zone or whether they're operating daylight or standard, correct?
If
there's no law, the law relates to changing times as it relates to standard or daylight. There's no law that says somebody has to open business or school or work or anything, correct? That's just a habit or a custom or a practice, but it's not required.
If we look at history, when nations go to permanent DST, they don't adjust. They sleep less. They get in accidents. Lives are lost. And if you were to adjust somehow everyone's schedules, then that would undo the benefit. There would no longer be this perceived extra hour of work, extra hour of sunlight after work. It doesn't make sense. It would take years to evolve, and history shows that societies don't evolve. This was tried here in the US in 1974, and it failed. It was tried in the United Kingdom from 1968 to 1971. No one adapted then, and it failed. It was tried in Russia from 2011 to 2014. And there's a lot of scientific studies that were performed showing that society does not evolve. They don't shift their schedules. Instead, they sleep less, their health suffers, they get into accidents, they get sick. The school grades suffer, workplace productivity suffers.
Thank you, and I appreciate your providing your references. I'll look forward to comparing them to what appears to be 180 debate given by the proponents with similar sources. So it looks like a good debate, Mr. Chairman.
Thank you. Thank you. No further questions. We're going to move to the neutrals. Jim Reed with the National Conference of State Legislators. Mr. Reed, are you on WebEx?
Yes, Mr. Chairman, I'm here.
All right, Mr. Reed, I'm getting up against the clock here, so I'm going to have to limit you to about 5 minutes or less.
That's, I understand, Mr. Chairman, no problem with that. Good morning, Jim Reed with the National Conference of State Legislatures. We're your resource on a whole variety of issues for the state legislatures across the nation. We're also in your neighboring state of Colorado. To quickly answer one of the questions that came up earlier in terms of which states stay on standard time, they are Arizona, in fact, and Hawaii, and also the territories of Puerto Rico and U.S. Virgin Islands. I did send in some slides, but I'll just speak to them quickly. NCSL is neutral on this resolution that's under consideration. We typically don't take a position on state activities. But we have followed this closely for a number of years, since 2014, 2015. We've had meetings and webinars on it very recently. And the topic has become of greater interest in those years. And really since 2015, there's been 350 bills across all the states on the issue of either staying permanently on standard time or staying permanently on daylight savings time. And you've heard that the standard time permanency is in the realm of the states. States can request that through legislative passage of legislation, and the U.S. Department of Transportation can grant that. However, it's not allowed to stay on permanent daylight time. The current mix of bills out there is about 80% in favor of the permanent daylight time trend. And Mr. Yates, who we have collaborated with in terms of sharing information, mentioned that 15 states, I think he mentioned that 15 states now have legislation on the books that would put the state into permanent daylight time should the U.S. Congress authorize such an activity. And those states I've included in the testimony I sent over. And that started recently in 2018, and every year now there's been more of a trend towards that passage of that legislation. In this year, in 2021, I did include a map that shows a number of states looking at this year, at least 27 by our count, and 50 pieces of legislation. And again, about 80% of these would adopt daylight savings time year-round, pending congressional authorization at some point. Let me just close by saying that it's an ongoing debate, and the arguments you've heard, pro and con, are very important. And so I basically would offer ourselves as a resource. We do have a web page that's included on the final slide of the PowerPoint I sent over, and we're happy to answer questions and refer you to resources. We did a webinar back in October that included some of the sleep research and then some of the information on both sides of the topic. With that, Mr. Chairman, I think I'll leave it open for questions. Thank you.
Thank you, sir. Do we have questions for the conferee? Yes, Arnberg.
Mr. Chair, I just want to make sure I understood correctly that all 15 states that have passed some type of either resolution or bill, all of them stated that they prefer daylight savings time and not standard time?
Did you hear the question?
Yes, I did. Mr. Chair member, yes, that is the stated preference in those bills. There are some contingencies in some of the bills whereby neighboring states would have to adopt a similar approach. One of the issues that's been raised through the various conversations across the country is the piecemeal map that we may end up with if some states do this and others don't, and will create more confusion about time zones. And really, the Uniform Time Act of 1966 was really intended to try and reduce confusion. But for instance, some of the New England states that have adopted this have said in their legislation that this would only be adopted should other states, identified in the bills, do the same thing. One of the, rather than calling it daylight savings time permanently, some have called it the time zone with the next time zone over. So in the East, it's Eastern time, they would shift to the Atlantic time zone. It would serve the same purpose. Time would go forward 1 hour. But that's been an approach in other states too. So for instance, a mountain state would say, we're going to shift to Central Time, and thereby, being on full permanent daylight and or basically shifting to another time zone.
Thank you. Further questions? Seeing none. Thank you for appearing by WebEx today, sir. Reed.
Thank you, Mr. Chairman.
Committee, I will direct you to the written neutrals, Allison Manzi and Association of Broadcasters. Anyone else appearing who wishes to offer any testimony in these proceedings? Seeing none, then I will close the hearing on HCR 5008. Committee, at some point in time, you may see this again, but not tomorrow. Yeah. I did mention that I had a call of the chair, I believe, for tomorrow. We're going to be on, I think, pro forma tomorrow. I'm going to ask the committee. We can take the other bill up that we heard earlier on Tuesday morning, but we can take it up tomorrow. I'm going to be here, but I don't want to impose on your time. So, who would like to meet tomorrow?
What time?
Our normal time. Okay. It looks as though 3 are here and the rest are abstaining to vote. Then we will take this up Tuesday, the bill that we heard previously. I know spending all week up here, and some of you have great distances to travel. So if we are on pro forma, which as I understand we will be, and not be working any bills on the floor, I think you probably need the additional time off. So we're set for Tuesday, correct? With that, anything for good of the committee? Representative Miller, you can come and have your chair and go over the past bills or whatever, but you're always welcome to come to committee, and I may be here myself.
Yeah, I'm going to read all these articles they referenced.
Thank you. We're